All right, we're live.
Hey, good morning. We are back in Senate Judiciary. It's April 17th, and we have S29 again in front of us. And we have, not going to be able to pronounce your last name, so.
Sometimes I can't either.
But please feel free to introduce yourself and share any thoughts you have. I know some committee members might have questions about AOT's policies and yeah, so the floor is yours.
Absolutely, sure. So yes, Craig, DJ Marino, Vermont Agency of Transportation, and working in the Leaders Division. Been here for 20-something years. S29 is a bill that we're meet and stand behind. We've been doing a lot of snow and ice control practices over the past years. We have a safe road, safe speeds policy, not a fair road policy. And that guides our goal of efficiency for songs. Some years we have reductions, some years we don't. It all depends on the weather and road conditions. So we're actually seeing some increases in salt usage over the past couple of years, just because we have more of these thaw cycles. But S29 is, I don't know what version you have in front of you. I know there's multiple versions out there between H86 and F29. There are salt requirements for getting those undercover, which we have 100% of our salt piles undercover. We have 4 of our sand piles that we have that aren't charged with sand. We've got 1 pile of sand that's charged with salt. So the bill doesn't impact us greatly. We do have a Vermont Local Roads program that's touched on in the bill that would support municipal training. They already provide municipal training for fluoride reduction, as well as best management practices for road construction for gravel roads. So the goal there would be to work with A&R to expand that program. So to reach out to more municipal salt applicants for this voluntary program. So I will say that it is a voluntary program. I'm sure you've heard from others that an incentive would be great to have keep in the bill. Not sure what that incentive would be. I know right now it's a limited liability protection. I'm not an expert on that at all, so I'm not going to touch on that. But an incentive would be good to get the commercial opportunities in the door. So the Safe Roads, Safe Speeds policy, it really just resets expectations. You see the variable message boards out there. We do public outreach. We inform users of our rights of way, our roads in our rights of way, and that's what it's for only. It's not for parking lots. It's not for commercial locations. It's for our interstates and highways only. So we're setting a reduced expectation, and we're using salt as efficiently as we can on those road networks. Under that policy, we have a whole suite of EMPs that we use that are everything from clearing trees on the side of the states that have more sunshine or solar exposure for melting, through to equipment that we use to calibrate or adjust how much salt we put down in the spinner based on speed. We have surface temperature monitors on our trucks. We have remote information, weather information systems that we've seen on 511 probably if you've been on that system. We've got cameras that the public can use to see what the road conditions are like, from the out the road, and you decide to stay home. So there's a whole host of practices we implement to put the policy into effect.
Thank you.
I'll stop there and open it up at this point, if that's okay.
Any questions?
Do have a couple of questions. Are the state AOT salt applicators trained in the manner sort of being suggested in the bill?
So we hire snowplow operators and they are trained, but they're field trained, they're trained in the garage. They don't go through an official training program, but it's part of their onboarding process that they are trained on the equipment they use. They're inspected after they plow the routes. We have folks that drive after they plow routes to make sure they're not spreading too much salt. And it's fairly easy for us to tell because if there's salt smelting beyond the white line, then you know maybe they're filling up too far or using too much. So they're not officially not trained on any program.
Okay. And and this may be a question actually for ANR and not you, but I'm gonna ask, do you have a sense of what Vermont's salt load is comparative to the states around us, New Hampshire, New York, Massachusetts?
I do not.
Okay. That is so the other question that came up, and again, it may be a question for you, it may be a question for ANR, is if there's a sense of where the majority of the salt is coming from. There was someone who testified that it's coming from the highways, which is your area of plowing. And so I'm wondering if you have a sense of that.
So I don't have an exact number for you, but the testimony that I've seen this session about this bill suggests to me, and I wasn't able to find that particular session, that the commercial applicators, the commercial properties are the largest volume of impervious surface. So it makes sense that they're the ones who have the most amount of salt coming on the ground. Municipal applicators would be next, and then we be third in terms of amount of salt being used. ANR was going to look at impervious surface. I did try to coordinate with them before we showed up today. They were hopeful, I was hopeful that they would bring some of that information in for you. That was my recollection based on the testimony I heard this year.
Okay. Yeah, like I said, I knew that it may well be an ANR question. If you were here, and maybe you knew.
Absolutely.
Is there any, or what are your thoughts on doing a more formalized salt reduction training with your people, your staff?
I'm sure we could work that into their onboarding process. I'm not sure what that would look like.
Yeah.
But that would be a maintenance leadership. But I can't imagine it's something hard to say.
Okay.
You mentioned that you contract out with private plow operators, or did I misunderstand?
Oh, sorry. No, if I said that, that's incorrect. No, you do not.
I probably misheard. So, okay. Are there, I think I'm kind of getting out of judiciary jurisdiction for a second, but are there guidelines and rules that that private plow drivers already have to follow when it comes to how much salt they're putting down, or are they just free to?
I am not aware of any, and I wouldn't be the expert on that at this point.
Really, any other questions?
No, it's just like you said, it's hard to determine if you're saving on salt just because every winter is different. And you have a lot of technology in the trucks. I heard from others, do you have like GPS in the trucks that kind of have problem spots, things like that, or bridges that click on the system, put salt out?
We do, and we're actually using that to meet our TMDL compliance obligations up in Colchester for the Sunnyside Brook chloride TMDL. We have geofencing around that watershed, so when our trucks cross over into that watershed, it actually signals the driver to ratchet it down, and we actually track. We track all of our salt usage, but we're more aware of the tracking the amount of salt storing in that environment.
Do you have any further testimony or any additional thoughts you want to share?
I don't at this point. I'm happy to stay here, and if something comes up, jump in again. Pass the torch to Mr. O'Grady and great there.
Thank you.
Absolutely, thank you.
I think we already got the walkthrough, so I think we're potentially doing markup, but is Captain Sergeant on the Zoom?
Yes.
Okay.
Hi.
Hi.
So for the record, my name is Bethany Sargent. I'm the Deputy Director of the Watershed Management Division. So I certainly can answer questions that the committee had. I want to just reiterate, I know the committee has heard some testimony on this bill already, but wanted to reiterate that the problem of increasing chloride in our surface waters is well documented around the state, even in Lake Champlain, our largest volume of water. We also have seen it reach concentrations that are documented to impact aquatic life in our surface waters. So we have seen concentrations in excess of our criteria and our water quality standards, particularly in small watersheds, which have a high impervious surface relative to the watershed size. And so at this point, we have 8 surface waters that are impaired as a result of excess chloride. We also know that across the state, and I understand, I heard the question about the percentage of surface water, or excuse me, the percentage of impervious surfaces in terms of how that breakdown occurs at the state. So in doing some GIS analysis to estimate those percentages, so state roads roughly, and it's going to vary a great deal across the state, watershed to watershed, but across the state, state roads make up roughly 19% of the impervious surfaces that we would salt. So think, of those impervious surfaces, paved roads, sidewalks, parking lots. So state roads make up approximately 19%. Municipal roads would make up about 26%. And then other impervious surfaces, parking lots, sidewalks, et cetera, which couldn't, the bulk of which are going to be managed by commercial entities, make up about 55%. We did some more specific analysis for Sunnyside Brook and Colchester. That's this stream that that was mentioned that has a TMDL, or total maximum daily load, and we found that the other paved surfaces beyond the municipal and state roads made up more than 70% of the watershed. And so we know that those commercial surfaces or commercially managed surfaces are one of the more significant aspects of these watersheds, particularly those that are impaired. We also, in developing the Sunnyside TMDL, we needed to estimate those sources, and VTrans, is able to quantify the amount of salt that they apply in any given season, and it does vary a great deal from season to season. As is, Colchester, the municipality there. The commercial applicators, we don't have any ability to know how much they're putting on. And so they sort of make up the greater majority of that salt, knowing how much the municipality applies and how much VTrans applies. And so this is really an important step forward in reducing and optimizing really the amount of salt that's applied in snow and ice management. I also understand that the committee has heard testimony about the, just concerns around not knowing what those best management practices would be relative to the limited liability portion of the bill. And the agency proposes to incorporate, into S29 a requirement to adopt those best management practices and the requirements of the certification program by rule, which would allow a public process and full public participation in evaluating those best management practices to optimize chloride use. We have partners in the state like VTrans who are very knowledgeable, and there are similar training programs and certification programs sort of in the northern portions of the country. So I'm sure you've heard of New Hampshire's program, the Green Snow Pro program. There are also similar training programs in Minnesota and Wisconsin. And so, obviously there are a great number of experts in the field to engage in the process of developing those best management practices. That rule would be updated on, a 5-year basis, could be updated in order to incorporate, the latest science and technology available to ensure that, that we are truly using the best management practices that will optimize salt use so that it is effective. And there are, instances where if the temperatures are too low, salt's not going to be effective. And in communicating with those who run New Hampshire's program and others in the field, the limited liability portion of this bill is important in incentivizing participation and in changing sort of the practice of over application of chloride because of some of those concerns. So I'm happy to entertain additional questions if you have any.
Committee, any questions? Not seeing any questions, but just kidding. Senator Moskowitz.
So I know we've heard from New Hampshire that they have no real data to know if this program is actually working to reduce fluoride. Do you know if Minnesota or Wisconsin is there data out there that shows that this actually works? Like, I too want to solve the problem, and no one can tell me this works.
From the applicators that have participated in the program, I think there is, evidence that they have seen sort of a reduction of their salt purchased in some, anecdotal cases because of the variability of winters, because of the variability in any given location and when salt is applied, and how it's difficult to say on the whole that you can demonstrate a reduction in salt overall. The idea behind the best management practices is around salt optimization and reducing that over application. And really, to maintain safe surfaces and to optimize salt use are the objectives. And, we have seen that can lead to, that can prevent the over application of salt because of all of the variables that exist in the program. And because it's even estimating what our current salt use is without the program is an unknown, that answer is really difficult.
Okay. Thanks.
Committee, any further questions? Great. Well, thank you for your testimony. Appreciate it.
Thank you.
So, committee, I'm trying to think of what a possible solution is for this bill, because I know that the liability piece concerns some, but also it seems like there's a general desire to reduce the application of salt, which makes sense. So one idea I had is whether, and Mike, I'd be curious of your opinion on this as well, if there is a way to, rather than creating immunity from negligence, just creating an affirmative defense against civil liability and saying that if these elements are met, then the defendant, the plow driver, has an affirmative defense. And, the affirmative defense it's not as strong as blanket immunity, but it is stronger in that it could mitigate the culpability of the offense, or it could just lead to an acquittal, but it doesn't automatically close the door on the plaintiff's claim either.
I think in civil, you probably, instead of calling it an affirmative defense, you'd probably call it like a rebuttable presumption. But it's the same concept. And I think you could do that. You saw that in the existing right to farm law that's in Vermont now, currently, that they're presumed not to have caused the harm unless something else is shown. I think you could do that. I think that there's a way to do that.
Thank you. Committee, any thoughts on that?
Be curious to hear more about that and how it works against in tandem with the immunity part, I guess.
With what was the last sentence?
Well, just like how that change would affect the immunity part of it.
Yeah,
Are you thinking like what you're thinking?
what I'm proposing is not having immunity,
Yeah.
rather having you know, if the defense can prove we met all these elements, then they're in the clear. And, but it still provides the plaintiff an opportunity to say, you may have met all these elements, but there's this other thing that happened that regardless of those elements, you're still culpable for negligence or whatever the offense might be. That's what I'm trying to get at.
So is that any?
Oh, I was just gonna say, and I don't know that I understand these concepts well enough, but I would say, immunity sort of renders the argument, in some way, and rebuttable presumption just changes who has to prove what.
Yeah.
So it seems like a rebuttable presumption is desirable, but not as desirable as immunity.
If you're a plow driver.
Right. So if we change the bill in that way, we're reducing the protection on one side, but we're potentially mitigating the problems with liability and for personal torts. Because that was the argument, was that we were getting into this area of law where we're immunizing people from personal harm to other.
Yeah, I think that, and yeah, it's my opinion too, that just getting into an area where we just provide blanket immunity, that can be concerning if there are other factors that exist that would otherwise be considered just aggravating or just outrageous. And so I think that having an affirmative defense or the rebuttable presumption creates that incentive, because prospective defendants will know that, all right, if I meet all of these elements, I have a strong defense that could either mitigate culpability or just lead to an acquittal, but it doesn't outright shut the door on a plaintiff who actually has a legitimate claim and has been harmed. So that's what I'm contemplating.
I mean, it makes sense to me as a compromise between the two sides. We haven't really struggled, but it's but that's the area of potential disagreement. So
So what would somebody need to prove to show the affirmative defense if they took the BNP training, that they were certified, and that they were applying or they applied according to the BNPs?
Yeah, that's what I'm thinking. I hadn't made it that far in my brain, but I mean, I was essentially thinking of just, you know, whatever the elements are to allow for immunity right now, just make those the elements for allowing a rebuttable presumption.
I can work on that. I'd like to work with Eric on that. Just how to shift so you don't wind up with the situation that you had with like the farm where the defendant was having to prove all of the things that was necessary to get the rebuttable presumption or the protection to. I'll work.
I think one of the larger issues from the right to farm piece and the defense proving that is it was extremely vague and unclear in the original right to farm. I think that with this, if we're just saying you take this class, that's one of the elements, and then I mean we'll make sure the other elements are actually clear so that we don't come back with 3 or 4 years and there's an issue with a lack of clarity. I think that could be a reasonable path forward. Does the committee have thoughts on that or want to think on it?
I want to think on it. I think I like it more. Friends with blanket immunity, but I want to understand it more.
Yes.
Not an attorney.
So I do have one question. Where would I find immunity, term immunity in here?
Where would you find what?
The term immunity in here? What page is that on?
It doesn't say immunity, it says limited liability.
Okay, so the difference between immunity and limited liability is what, Mike?
Well, immunity, you're normally free from all liability. This is, well, limited liability. It's not immunity per se. For example, in order to get limited liability, you have to be certified. You have to be applying according to the BMPs. You have to be submitting records. And then the hazard, the harm that you would be limited in your liability from has to have been solely from the snow or ice and arising from your application of the BMPs. So an attorney has multiple opportunities there to pierce the limited liability, saying the hazard wasn't solely from snow or ice, that the applicator wasn't following the BMPs. And then there's also a umbrella provision that says if the harm was caused by gross negligence or reckless disregard, the limited liability does not apply.
So we're really discussing limited liability and not immunity, correct?
Right, I mean, people are using the term immunity in both houses, but it's really limited liability. Thank you.
I'm just thinking more on what you're proposing. And getting into those frivolous lawsuits that then the contractors put in the position to prove that they did X, Y, and Z. Versus having like to being able to say you didn't do this, didn't do that, didn't do this. Kind of takes the teeth out of the bill.
I'm sorry.
Kind of take the teeth out of the bill. I feel like the incentive as to why you'd want to go through the course and have to maintain your records and do everything to get that limited liability. Because it sounds to me, how would that be different than it is today? If somebody sues me for slipping and falling on a sidewalk or a driveway that I plow or clear snow.
I mean, how would they not have to prove that they aren't meeting the requirements or the elements if they have limited liability? I mean, they would still have to prove I went through this course, I was applying the salt per the guidelines and whatever other elements there will be.
I guess I don't know the legal difference between limited liability and what you're proposing now.
Well, it's an affirmative defense to. So it would be saying that. I don't even know. Now I'm just swirling around. So
So in an affirmative defense, the plaintiff brings a claim and says you were negligent and you did not follow standard duty of care, there was harm. The applicator says, I have the affirmative defense against negligence because I completed the certification, I was applying according to the BMPs and the harm, whatever other criteria you want to add for the affirmative defense. So it's on the defendant to show that affirmative defense. Whereas with the limited liability, it's on the plaintiff to show that the harm was not solely from snow or ice, that they weren't following the BMPs. It's a bit of a shift. And negligence is still there. You can still bring negligence, just at that standard. And so it is a more opportunity for the plaintiff, but still opportunity for the defendant to have protection of whatever criteria you want. It's met.
In this case, in our case.
Is it less of an incentive? I think that really depends on what you build in as the criteria. Do you want?
I would also want to hear from the
Have a seat.
trial
It is not working.
attorneys or whomever,
Love
the
them.
people who are worried about the liability,
Yeah.
if this is their concerns.
Yeah.
Like I said, I don't feel, I just feel like I need more information as we kick this around as a possible path forward.
Okay.
The House is looking at their version of it as well, which I expect that you know.
Okay.
And they're following the limited liability, but they are, as Bethany referenced, they're gonna require PMPs by rule by July 26th. And then the liability provision would not go into effect until January 27, and they're still working on the dates. But their concept is to give advocate stakeholders, opportunity to be involved in the development of the BMPs during rulemaking. And then time for the commercial applicators to get trained up before limited liability would go into effect. And then they would have a similar program for municipal salt applicators who were looking for similar limited liability protection. And I don't know where the bill is going to wind up, but it has been a pretty, I won't say vigorous, but there's been a lot of discussion.
Almost never mind, just let them deal with it.
I would really be okay with that.
All right, well. I guess we have some thinking to do for a little bit. Committee, any further thoughts or questions?
No, I just, if I might, I just think, yeah, there's more thinking done about this because I don't want to shift the needle one way or the other here in favor of the plaintiff versus the defendant. So I'm not a big one of rebuttable presumption. As you well know, I don't care if someone accuses me of something. That shouldn't be up to me to defend that. It should be up to them to say, okay, well, you should be proving this, such as the state does in criminal cases. The civil court work differently, I guess. But I guess I'd have to wait and see how this all sugars off to see which direction we're going here. But I don't want the needle to be leaning either way. I want to find a compromise here. What I'm looking for, I guess.
Anything else? Yeah. Mike, thanks for, appreciate it. You're welcome. We're all set.